our second session on the forensic science strategy. We already had some very interesting evidence given to us about the implications of the proposals that were put forward and concerns about the absence of statutory powers for the regulator so far. But I wonder if I could start with you, Dr. Maxton. The Royal Society has recently announced the launch of a project which is developing primers to help with the interpretation of scientific evidence in courts, help, I think, assist with what is perhaps good practice or not good practice. Can you explain what your motivation for this is? I think that this is a proposal which Professor Silverman has also been involved in developing.
Thank you, and thank you for inviting me here to the committee. The primer project is really, Bernard Silverman did have a part to play in it, and it's in his forensic science report of 2011. But also it has its part of its genesis in Brainwaves report that the Royal Society did in 2011-12 as well. And the Lord Chief Justice has been interested in it since then. And in fact, in his Calashire lecture of 2014, he talked about how useful primers could be. So part of the role of the judiciary is to act as the gatekeepers for the admissibility of evidence. And with that responsibility in respect of scientific evidence comes a necessity to know how robust the science is that underpins the type of evidence that's going to be presented to the trier of fact, which in a criminal case, of course, is the jury. And we think that by having short statements in plain English, which are prepared under the authority of the Royal Society and the Royal Society of Edinburgh, then it will assist judges in that role as the gatekeeper, because it will explain how far the science goes at any given time and what the limitations of that science are. And so a judge can then decide whether or not to admit it, and if it's admitted, the kind of weight that could be placed upon it.
Thank you. So Professor Silverman, when you sort of originally made this proposal in 2011, you used the example, I think, of patent law, where
yes.
they already have these primers.
Yes.
But you said that you thought that it would be quite difficult to produce similar primers for forensics. Could you sort of elaborate on what those difficulties might be and how perhaps you might seek to overcome them?
Yes. So the origin of it in my 2011 report was that I had evidence from, he wasn't Lord Chief Justice then, but a future Lord Chief Justice. I went and discussed it with him and his colleagues, Lord Justice Hughes in particular. And the example they gave me was how these were used in civil cases, where both sides of the argument would agree in advance of the actual case coming to court of what of the science they agreed with each other. And I think Dr. Maxton's been very helpful in placing the matter in the criminal law context and saying that, of course, ultimately it's the jury that matters. So I think that working through it in the way that the Royal Society have done with the judiciary has been absolutely fantastic, and I'm very optimistic. Although I'm not a lawyer, Dr. Maxton is a very distinguished lawyer herself. I'm now. It's very good that this has been taken up, and what I had hoped in 2011 was that authoritative scientific bodies like the Royal Society, neutral, independent scientific bodies which would carry authority within the court system, would take this up, and so it's really excellent that this is happening.
So how's it going to work? What are the subjects you're covering at the moment, specific specialisms? Do you think that they're going to reduce the number of expert witnesses in court or change the way in which forensic results are used? What is your definition of success?
Can I start with how is it going to work?
Okay.
So can I emphasise that it's a pilot project at this stage, because it's untested, of course, and the way we've set it up is as follows. We have a steering committee, and on the steering committee, it's chaired by Lord Hughes, who sits on the Supreme Court. It has judges from the Court of Appeal and First Instance in England, and it also has a judge from Scotland and a distinguished fellow from the Royal Society of Edinburgh, Muir Russell, who's on the judicial selection panel in Scotland. And it has Fellows of the Royal Society and Fellows of the Royal Society of Edinburgh. So that's the overall steering committee. The first topic is going to be DNA, because it's widely used in court, and we think that would be one which we could test the temperature of the water of how this would work. So to do that topic, we've set up an editorial board, which has on it Sir Paul Nurse and various others of that calibre. And then there's a writing group. So the group they'll write it, and they'll write about DNA in a way which is in plain English. It'll be ratified by the editorial board, and then it will go to both councils of the Royal Society and the Royal Society of Edinburgh, so that it has the imprimatur of both bodies. And the idea is that Bernard instanced the patent cases. Patent cases generally have clients that want more resources than clients in criminal cases. And so what happens in patent cases one can understand, because people get together and they can organise what they agree about. It's rather different in the criminal world, but what we're doing isn't necessarily going to be limited to the criminal world. But it would be just helpful as scientific techniques develop, and develop quickly, for judges to have an understanding of where we are with the science. And we get examples with DNA, mixed profile DNA, which is complex, and surface-to-surface DNA, which is much more complex than just a little piece of DNA. And so the further you go down that trio of issues, the more complex it is, and the more difficult to explain to juries, I would think, how robust the science is that underpins it. So we think by doing that, we can help judges. But I do stress that this is demand-led. This is not something that we have invented. It's come through discussions with the judiciary, and we need to see whether it will help the judges. So it's only a pilot, and DNA is our first one. We're also looking at doing gait analysis, because in courts apparently judges spend quite a lot of time looking at CCTV pictures of how people walk, and so we're looking at that, but we haven't set up the groups yet. And as to other topics, then that depends upon what the steering committee, and they're the ones that talk to the judges at the cold face, and we'll pick it up from there. So what does success look like? I think if the judiciary were to feed back to us that the primers were written in helpful language, that they did give them some guidance as to the robustness of the science that underpinned some of the techniques, but also emphasised its limitation, then I think that we would be quite pleased.
Well, you'll be on the way. Okay. So, Professor Silverman, final question before I pass to members of the committee. Obviously, this started with patent law, moving on to forensics. Do you think that this is a technique which could be applied to new technologies as they come forward?
In forensics? Yes,
well,
patent
not
law
just
was
forensics,
you
perhaps
mean
further out. I mean, I'm thinking maybe digital.
Well, yes, digital will be part. If it's digital forensics, that's within the current consideration. I have to say that what's been described is the dream outcome. The very, very top scientists and lawyers in the country getting involved in the primers is the dream outcome, in my view, of the recommendation. Of course, it's taken a while and it's only one, but I think the idea that there should be genuine, agreed scientific authority is really excellent. And I think the slightly cautious approach we're taking, one thing at a time, seeing how it works out, will in the long run pay off. And so I think it's very encouraging.
Thank you very much. Tanya Mathias.
Thank you, Chair. Could I ask you, perhaps Dr. Maxton first, no reason. What do you think are the main barriers to understanding and interpreting forensic evidence in court? Is it the lawyers and judges, or is it juries, or is it both, do you think?
I think probably it's understanding the science that underpins it and explaining the science to the juries. I think that's the key is the key thing. In the criminal field, I mean, in the civil field, you still have to understand the science if you've got scientific evidence in front of you. But you can use, I mean, you can always use expert witnesses, and I don't think the existence of the primers will cut down necessarily the need for expert witnesses, but it might limit the field over which the expert witnesses disagree.
Right, got you. And Professor Silverman, would you agree?
Yes, indeed.
You would. Okay. So, do you think lawyers and judges need more? Again, just for no reason. Ladies first. Do you think lawyers and judges need any extra training?
That's not any part of what we are doing, actually.
Right.
So.
But do you understood? But do you think they need it then? If you think the concern is the understanding at the jury side, do you think that?
I don't know if it's training. It's just having science presented in a way which is accessible. There's probably a dearth of places that anybody can go to see what the current state of the science is, because the way science works as an iterative process, it can lead to a kind of clash of cultures. What's certain, or all of science is really about as far as we know, and scientists use concepts of certainty and lawyers use concepts of certainty and proofs, and you sometimes get a clash of cultures.
Yes.
And so I think presenting science in a way that is accessible to judges and usable by judges, so it's not too complex nor too simple, because it has to explain the limitations,
yes,
would perhaps be helpful. But I don't know if it's to do with training. I think it's more about giving them access to things they already need to go to.
Yeah. And would you agree?
Yes, I mean, I think that it's, to me as a scientist, it's obvious that it's really good if people who are using science should understand it, should be aware of it, and I think Julie's being a little bit modest here. I think that the documents like this one will naturally be the things that lawyers and judges will want to read, and they will naturally form part of their training. And so it isn't that one has to mandate that they should do this sort of training. It's that if out there are simple, easy documents, then everyone will want to read them, and I think that's a strength. And I should also say that this Primers project is the tip of a larger iceberg of contacts between the scientific and the judicial communities. There's work being done by the Isaac Newton Institute in Cambridge, who are running joint workshops. The Royal Society itself has run a number of very interesting joint seminars, and the fact we're all working together in this way is, to me, again, very encouraging.
Excellent. Okay, thank you. Do you think there have been any cases of misunderstanding which has led to, dealing with forensic science, which has led to a miscarriage of justice, Dr. Maxton?
Well, probably there's one case that, of course, probably nearly everybody knows about, and it's the Jill Dando murder trial, where a suspect called Barry George was tried and convicted of her murder. And one of the key pieces of evidence was gunshot residue, which was found in his coat pocket. And on appeal, it was determined that the particle, the gunshot particle, it was no more likely that it came from a weapon fired by Barry George than from any other source of contamination. And the thing was that this was a long time after the event, and his coat had been put on a mannequin and it had been photographed, and there are all sorts of interventions. So, I mean, that's possibly one example. And if perhaps I could just supplement with your permission, Chair, one of the points that Bernard has made. We are doing other work, and out of the other work that we're doing with the judiciary, we've done 3 seminars, one on memory, one on probability, and next one in October is on mental capacity, and we have a programme planned for next year as well. And out of some of these seminars may well come further primer projects. And the other thing to say, of course, is that law and science, whilst they have many commonalities, have a key difference, and that is that law is jurisdictionally limited and science is not. And so if these primers are useful to the judiciary here, they might be useful to the judiciary elsewhere.
Right, okay. Are those seminars available webcast and online?
No. Okay. Not at the moment. We start everything small.
Okay. Would you agree with what Dr. Maxson said?
Yes, I'm not qualified to talk about specific cases,
sure.
But yeah.
Okay, and just finally, the forensics regulator is asking for the forensic scientists and labs to be accredited. Do you think that will help in the courtroom? Again, Dr. Maxson, please.
Well, that's not really my area of expertise, and I would defer to Bernard.
Okay. But obviously, because if evidence is to be taken seriously, the process by which it's obtained has to be reliable, and accreditation is obviously an important part.
Okay, thank you.
Thank you. Graham Stringer.
Gillian Tully told us in April that there'd been a diminution of research and development in forensic science since the Forensic Science Service had finished. Do you think that is a consequence of the failings to look at the scientific implications more widely when the Forensic Science Service was finished, or is it the fact that when you examine the R&D landscape in your review of 2011, the implications of that weren't carried through?
I think quantifying the amount of research in areas is difficult always. So, and I don't have any comparative figures with what was done then. What I've tried to do is to keep an eye on what research has been going on, what's important. I mean, for example, I decided to look at fingerprint-related research, and I think we've got a project going at the moment. We've given you the results of the draft. You can see that there's all sorts of stuff going on, all sorts of research going on, which maybe isn't surfaced. And so what I've tried to do is to draw together a map of all the different academic groups in the country that are doing fingerprint-related research, and you can see that it's quite a healthy group. I think what comes through in the evidence that you've received, and I was very interested to read it, is a mismatch between the experiences of those doing the research and the perceptions of the research councils in funding it. And I think what's important going forward is that we should have clearer routes to funding of research so that those doing this important work understand that their proposals will be looked at. And that way, the important thing is that the right kind of research is done, that which has the most impact. And I could expand on any of those topics.
There are a multitude of questions
exactly.
that arise from that answer. One, do you disagree with what Dr. Tully is saying?
I can't agree or disagree. I mean, I don't sense that it's actually the case that research has diminished in the last few years. I went recently to a conference run by the Home Office at which there were a large number of posters presented by young, enthusiastic researchers in all different areas of forensic science, and I was actually very pleased with that. And so I don't have a baseline to judge against. I can't say there's more or there's less, but I can say that there is actually quite a lot of really interesting stuff going on.
The second question that sort of follows from your answer really is the debate we had in this committee a few years ago, that the ending of the Forensic Science Service would lead to more work being done on that work in those areas that were open to commercial, because they were repeated processes, like in DNA analysis and fingerprinting. They were open to sort of repeated processes, and you lost the contextual forensic science. And the example you gave of fingerprinting is clearly one of those repeat operations. So do you think there's been a loss in the contextual forensic science area?
Well, I think the REF impact system, the Research Excellence Framework, so forgive probably most people in the committee know the acronyms. The Research Excellence Framework impact system should, if it works right, ensure that the research that's done is contextually based, because if it isn't, it won't have the impact that it needs to have.
Right. What impact do you think the new UK Research and Innovation body will have on forensic research?
Oh, the new UKRI. I think that would be very good, because for two reasons. Firstly,
sorry, I don't want to interrupt.
So is that the one
do you think it will deal with the contextual analysis?
Yes, because of the importance it gives to innovation as well as research. So joining innovation and research together should certainly, not just in this context, but in every context, say that science is very good, and even better when it's in a context where it's put into useful operation.
And if you were to come before this committee in 2 or 3 years' time, will you have a baseline study so that you can show that?
I think that's a task. A baseline study. Well, I think the survey we've done on fingerprint research, and we intend to do those to do deep dives into other areas, that would provide maybe not a quantitative baseline, but it would provide a qualitative baseline.
But not just in single areas, more generally.
Well, I don't. I mean, if I'm looking at forensics, I can only look within forensics, but it's clearly one of the intentions of the strategy that the Home Office, and therefore the Home Office's Chief Scientific Advisor, should monitor and should use convening power to see what's going on in the forensic science area. Yeah.
I mean, there is this perception out there that it's difficult to get money for research into forensics.
Yeah.
We've had evidence that when police forces are working with academic partners, they submit bids, they're not successful. Do you think the UKRI will solve that problem? Will it help? And if so, how?
Well, I hope the UKRI will solve the problem. So the other thing that went on within the nurse review was the idea of departments producing statements of research need, which will then be coordinated by Sir Mark Walport's office and passed to the research councils. And the Home Office made sure that it got in early in this process, and our draft is with Government Office of Science at the moment. And forensics is, of course, an important area. So my hope is that aspect of the nurse review, in other words, getting research councils and UKRI to really make government needs an important strategic part of research funding. We've done what we need to do to feed that in. I think that the UKRI will be good for two other reasons. First of all, as I've already said, stressing the importance of innovation, and secondly, in facilitating strong cross-disciplinary work while at the same time maintaining the disciplinary pillars on which that sits. And so the join-up within UKRI is certainly a step in the right direction.
Are there any gaps, do you think, or any areas in the forensic science strategy which concern you, which you believe there might be improvements in?
I think the strategy itself articulates the biggest challenge, which is the need to respond to every aspect of digital technology, and that will present both technical and ethical questions. Another area is the likely disruptive effect of cheap genome sequence, and the strategy is honest about the need to influence R&D through a complicated interlocking system, and it states that there's no national mechanism for setting research priorities for the CJS. So I think a key issue is the UKRI needs to take seriously its aim of pulling through from research into innovation.
And if I can finish on the first question I asked, you didn't really deal with the point about whether you regretted not doing a scientific impact study and giving advice to the Home Office when the decision was taken to finish the forensic science service.
Well, I think that's something the committee's talked about before.
It is indeed.
So do I regret that I didn't conduct a scientific impact study at the time? Well, I think it would have needed to have been started long before I got into post to have a scientific impact study of the changes in governance and the rundown of the Forensic Science Service. And I think that's I don't have anything to add to anything I've said in the past about it.
Thank you.
Chris Green.
Thank you. Professor Solomon, so we're looking into unconscious bias.
Yes.
Now, so in our previous session, the Forensic Science Regulator saw a major risk around unconscious bias in forensic testing. So how well are these risks understood by the police, lawyers, judges and juries? And is there anything being done to increase that understanding?
Right, so I think we should talk about cognitive bias. Unconscious bias is something that everybody is subject to. There is actually discussion. Some of the experts, for example, Professor Itiel Draw, claim there is no such thing as an unbiased physician, that every physician is biased in some way or another. I would refer to Jill Tully's guidance, which is a really excellent piece of work. It's a very long document, and that shows clear engagement right across the piece. The way it was written by somebody who was from one of the forensic providers. It's got very, very detailed reference to the literature. It was looked at by the Forensic Science Advisory Council and so on. And so I think that this document actually it does exactly what a Forensic Science Regulator document needs to do. It really sets out, the issues out. It provides mitigating processes and so on. And so actually this is the expert document, and I would refer people back to it. So it's almost in itself a primer in the area. So although it's quite detailed and complicated.
So does there have to be, for wider dissemination, a reinterpretation of this information if from a very large detailed document?
I don't think
not everyone will
use. Yes. Sorry, excuse me. I think that what the document does is to surface a lot of what was already known here, of course, and make it explicit, and that's actually the main mitigating idea within it. And so obviously that is a public document for wider dissemination. I hope it will be.
Thank you. Dr. Maxton?
No. I have no comment.
So is there evidence that unconscious bias or cognitive bias may be influencing the outcome of investigations or even resulting in miscarriages of justice?
Well, I would defer to the experts who wrote the document. They clearly think that it could influence any decision at all, and so I don't have any specific evidence on that question.
Personally, I have no knowledge on that question.
And is the proposed establishment of the Joint Forensic and Biometric Service based within the police force itself likely to increase or decrease the reliability of forensic examinations?
In other words, if you set something up within the police force, would it be biased by definition? No. Well, I discussed this with Dr. Tully yesterday, so I actually said I'm likely to be asked this question, and I discussed it with her, and she said, no, you needn't be worried because everything is properly regulated, everything is properly accredited, and so just as with anything else that's done, the regulation is there to make sure that there isn't the problem that you suggest.
I defer to Bernard on this point.
Yes.
Thank you very much. Can I thank both of you for the evidence that you've given us? It's very helpful. We're very interested in the work that the Royal Society is doing on primers and the role that it will play in strengthening the forensic presence in the courts and the value chain that exists there. We hope that you might keep us updated on how that work progresses and also on the opportunities for the model to be replicated in other areas of future sites. We think it's a very helpful process. So thank you very much for the evidence you've given us. Order, can I call the second panel to the table?
Suspended. The proceeding is currently 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 suspended.
We will restart the session and welcome the Minister.
Thank you
Minister,
very much.
Thank you very much for coming to appear before us. We're very pleased to see you. I know that you are aware of our previous session in which we discussed the issues arising from the forensic science strategy, and some concerns were raised around statutory powers and research and development and a number of other things. Colleagues will raise some of those issues, but I just wanted to start with just high-level question, just the nature of the strategy itself. It did come rather late, obviously a couple of years after it was promised, and then when it did, it is quite a high-level document. It still speaks of continuing scoping work. So I'm wondering why is it so high level? Why is it not more detailed, given how long it's taken to produce?
I'm sure the committee is much more knowledgeable than myself in this, but simply because it is so complicated and such a fast-moving feast. I think the other issue which you touched on in your own, I know when I've corresponded with the committee as well, and I have this, I don't know what other ministers do, but I try and correspond with the committee much more than perhaps previous administration have done, simply because it's better for you to know where we're coming from, rather than being shocked when I arrive and say, yes, we're doing that or not, we're doing that. The other thing is that I'm quite determined that the strategy isn't a fixed entity. It has to be, with the nature of science moving forward and the nature of the technology as it moves. If we fix it and don't have, at this stage, fairly high brow, would probably a better way to describe it, well, then we'll lose the credibility, I think, of where we need to be, which is one of the reasons why. Its lateness is, I'm the minister, so I'll apologise for my predecessors. But I think you have to get it right. It's the degree of stakeholders, which is the modern word for this, is just astronomical. And I suppose the other thing is that because of what the committee had also said to do with the regulators and biometrics, stroke forensic, I just wanted to get it right, basically. So if I would have come in with a very basic document, which probably I would have understood a lot easier, I think I might have been criticised for being not highbrow enough, so probably can't win.
Yes, although, I mean, we had a lot of the stakeholders, as you say, giving evidence before us. And while you're right that it's important to have a framework which can accommodate technological advance and innovation, obviously we are also talking about providers who are in the private sector. They're considering employing staff, expansion, investment, and they need a degree of certainty as well. And one of the particular areas of confusion or uncertainty for them was the proposal for a national approach.
Yes.
Now, it said in the strategy that there was going to be scoping work to put forward business cases for a national approach to be completed by the spring. Obviously, that hadn't happened by the time we had our last session. So could you update us on that?
Yes. And I would like, obviously, to have done it by then. Because we are very much looking at the providers and making sure that whether that be from within the police or within the private sector, and I'm desperate to make sure that we don't have duplication and we get cost effectiveness and the quality of product coming through. Of course, the police's work they're doing at the moment on their capability review does have an ongoing effect as to where and who is going to deliver forensics. And I think one of the frustrations, and you've heard from the regulator, and one of the things that really concerns me, particularly with the private sector, but not solely with the private sector, is that we have the quality there of making sure that what is being put forward as evidence in a prosecution, and actually I think in many ways actually evidence is put forward in defence, has the credibility of the scientific profession as to how they go forward. It's not. I'm very open about this. I am very frustrated that the police capability review is not further forward than it is. It's holding me up in other areas, particularly in police funding. But this is an area which is now going to be driven very much so by the police, and where and who delivers that has to be a matter for them. But we must have the quality at the same time. I accept there is concerns about, for instance, R&D and finance side of it, but we'll get there, and then they'll know exactly where they are.
Okay, so if one of the roadblocks is police capability assessment
Yes.
at the moment, you could still help perhaps us by giving a vision for how you think you're going to match these two divergent challenges, which is a strategy which allows for innovation but still provides the certainty, the underpinning certainty. And at the moment it may be that external forces mean that that certainty isn't in the document yet, but what is going to be in there that will provide that?
I think what will be in there will be, and we'll come on to the regulator's powers and accreditation. I'm passionate about that. I was hearing only from the regulator that I have a real concern that people are calling themselves experts and going and doing work on particularly in prosecution side, which may not be accredited and probably couldn't possibly be accredited. So I think going forward is that contracts will be issued, but we need to make sure that the delivery is a nationwide delivery and expertise. So whether it being delivered at the NCA level or whether it being delivered at the ROCU level, the forces doing particularly their own thing, and that we're getting value for money for that. And that's an area which is still a lot of work still going on.
Okay. So you spoke about the sheer number of stakeholders being enormous, I think you said, or staggering. So in our last session in April, we had a number before us, and they said that they hadn't been involved yet in the scoping workshops for the national approach, and I think that this was sparking some of the concern about what that national approach would look like. So can you, and also
I saw that as well, and I asked my officials to address that. And I'm confident that if you call them back now, not all of them, because there are so many stakeholders, and invariably you won't be able to keep everybody happy. But that I saw that and I was surprised.
So who exactly is leading on this work and making sure that the right people are involved? Because it seems to us fairly obvious that the regulator should have been consulted, for example.
Well, I've met with the regulator recently and discussed this. It's a Home Office drive, and the regulator is independent from us, of course. But that doesn't mean that the regulator's influence shouldn't be absolutely paramount. I agree. But at the end of the day, the buck stops with me and my officials.
Okay, all right. Well, thank you very much. Tanya Mathias.
Thank you, Chair. In our April session, we learned about a draft document detailing the statutory powers for the forensic science regulator to enforce her codes of practice. Have the statutory powers been finalised? And do you know what the powers are?
The exact powers we need to consult. I need primary legislation. Okay. I've looked for other ways of delivering what we would expect the regulator's powers to be, but actually at the end of the day I need a vehicle. I would like to have put it in the Police and Criminal Justice Bill.
Yeah, but it appeared to, thank you for your letter, but it appeared it wasn't a priority.
It wasn't so much, I think I had a bill of 200 pages with 200 amendments and new clauses, and I think the pre-legislative scrutiny said to me in no uncertain terms, enough's enough, you need to come forward with another bill. And Parliament, quite rightly, does get concerned when governments come forward with so many amendments and changes to bills. And I think I bid for a bill with the Home Secretary's permission and the Justice Secretary's permission, which is a huge bill. And I think there was just concerns that I was adding too much to it and making too much. So I need another vehicle. And whether that is, there will be a Home Office bill, there always is, of some description. We will find a vehicle.
Okay.
It's a commitment I've made. We will find a vehicle for primary legislation.
Yeah, because obviously our concern, and I have to declare interest, I've got LGC in my constituency, and there is this concern about the deadline, October 2015.
Yes.
And therefore, when do you think the regulator will be given the statutory powers?
I can't give the committee that answer because it would be wrong of me to lead a committee down an avenue which I just don't have an answer, and ministers passionately shouldn't do that. All I can say is when I took over this responsibility, and I've not had it for that long, I was surprised at the regulator didn't have statutory powers, because I can't understand how you set up a regulator that doesn't. I'm honest about that.
Yeah, because you can understand. I appreciate you had so much in your bill, but you can understand as a constituency and being as on our science committee, this is a high priority.
And the chair and I have spoke extensively about this. And hopefully you feel from the correspondence I've sent, and I will re-emphasise that when I write back to the committee after this session. And if I could have had it in the bill, I would have had it. I'm a Minister of State. That's a subtle hint.
And in your letter, when you say police forces committed to meeting the accreditation deadline, do you know what percentage are?
I have the details of that. I can write to the committee with the full details of that. Of course, there are different areas. So with fingerprinting and as an example, but all of the new Chiefs Council have agreed this, and we're going forward. The area where I think is the more difficult area for the police to come up, which is why we've got the capability review going on now, is that the technology around. So we look at hard drives. Where if we're investigating paedophilia with the dark web, where exactly do we get that expertise from, and should that be held at a national level?
I've got to be so careful because of my interest.
Yeah. And my view is that while this is a decision very much for the police and the CPS as well, but predominantly with the police now, by holding it locally could speed it up, but only if you have the capability and the expertise. Whereas if you at a national level, there's
we get that.
Yeah.
We get that.
And that's really tough for some forces to give up, if you wish.
Yes.
Well, we can't do that. But I think the police are getting that now more and more in other areas as well as this.
Okay, thank you, Chair.
Can we go back to procurement? You mentioned this a little bit in the opening questions to me. But as I understand it, the current national procurement arrangements are due to expire on the 31st of July?
Yes.
So have we got details of what's going
to
take place?
The police have given me assurances, which I'll write to the committee with, as that they will move on now with their procurement. Some of those contracts, I suggest, and I'm speaking on their behalf, probably won't be long-term contracts while they continue to do the review as to where they are, but they have it in place, and they are giving me the confidence that they are happy from the end of July onwards.
So is it just a continuation of what's there now
they're
doing the capability review?
It is, and it's yes, predominantly it will be, yes.
Okay, so we're not moving to a national procurement arrangement of any kind in forensics, particularly, or in any other areas. Okay. So
that would be a complete against government policy to have gone.
So different police forces will be free to choose their own.
Yeah.
Okay.
But sorry to interrupt you, but the clear thing here has to be quality of the work that's done, the value for money as to how it's done, and the speed as to where we're going, especially now with the requirements within the bill for police bail not being extended beyond 28 days except in exceptional circumstances.
So if new procurement arrangements are being put in place, is this not an opportunity to require that all work done by police forces is performed by suitably accredited providers? Because obviously we're still waiting for a legislative vehicle for the statutory powers of the regulator, and this might be a way to...
I think I completely agree with you, Chair. If I'm waiting for the vehicle, that means I can't, at the moment, force the forces. But I will say on the record, I cannot understand any force used in a company which will not be accredited.
So are you able to put that into procurement arrangements in any way?
I can't at the moment. I think technically I do have the powers to do so, but that would interfere with the way that we want forces to develop their own strategies on procurement. So let me draft a letter to the committee. But I say again, the accreditation is there for a reason.
Yes.
And I find it difficult, and actually I'm hearing, and the registrar told me this, that there are occasions where there is real concern about the quality of the so-called experts being used. and the accreditation is for that. And if I find going forward, whether it be me or another minister in this position, that is being ignored, then the statutory powers can be put in.
I suppose
they can do it by regulation.
My question is, there's been a lot of delay
yes.
In this process already for lots of different reasons. And we have a delay waiting for a legislative vehicle for the statutory powers to come in to get the accreditation really well underway. There appears to be still resistance to using accredited providers and for different providers getting powers. And while everybody is interested in devolution of power and so on, and I entirely support that, there are occasions when intervention becomes necessary.
Yes.
And it does feel to me that in this particular instance, there have been lots of opportunities for all the different actors to behave in the way that
yes.
the government would expect and has signalled very clearly that they do expect. And so I just wonder whether this might not be an occasion to use those powers and not delay.
I reserve my position in that we have the powers to do so if we need, or if we can seek the powers to do so. I fully expect, actually, the conversations I've had particularly with the leads from the police on this, that this is where we will be. But as I say, if we don't, well, then my kind of devolutionary thought process and the government's devolution may need to step in, and I agree with you on that.
Okay, all right. And my last question on this were concerns that were raised around some of the procurement which was happening, where there was sort of fragmentation of procurement with perhaps a single case procuring different tests from different providers, and this leading to no single provider or expert having an overview of the whole case. And there were concerns about the robustness of the evidence that was coming forward as a result of that, and a question about whether there needed to be steps within the procurement process to try and address this problem.
I have to be slightly careful there, because I would be, if I'm not careful, I'll be interfering as a minister within a police investigation type situation, because I'm not a lawyer.
An investigation. It's
but I'm not a lawyer.
Process, which is leading
how a force put together a case against an individual is obviously a matter for those. I've heard a little bit, but I've not seen the evidence on it. I've asked a regulator, and I will reiterate that. She'll surely listen to what we're saying today. We will pursue that. I think it's a polite word of putting it.
All right, thank you. Graham Stringer.
Can I get the Brexit question out of the way first? There are research bodies in the country receiving Horizon 2020 funding for forensics. Have you done any work or contacted the Cabinet Office to see how that funding can be continued into the future?
Okay, there's no agreement in government beyond the present funding term. It's a bit early for negotiations beyond 2020. We as a Home Office, we did exceptionally well with the last funding round. But those sort of negotiations, I'm sure, will start. But 2020, we're 2016. It's just too early for me. But they continue to have it, because that success of getting it to 2020 was significant anyhow, I think. But we haven't started conversations yet. Being completely honest.
Right, thanks. This committee and its predecessors committee have been with the changes in the Forensic Science Service for some time and shown concern. This isn't a party political point, because I think the last Labour government made a mess of closing Chorley Forensic Science Service, and I don't think the incoming coalition did it much better when it closed the Forensic Science Service down. But it seems to me that there are two gaps in the service, and there is disagreement between Home Office officials and the regulator. One gap is the loss of the contextual analysis from the whole of when the Forensic Science Service went. And Dr. Sully has been in front of the committee on a number of twice, and told us that she thinks that it's likely that people guilty of serious crimes are getting away because of that. So that's one gap. And the second gap is because so many researchers have moved out, is whether there is enough research being done. I'd say it's not a party political thing, but one gets a defensive response from the officials involved. And I wondered, as a minister, whether you're as concerned as I am about those two gaps in the service.
Firstly, thank you for being so honest about what's happened before, rather than just saying there's nasty, horrible new government. And in hindsight, lots of ministers would say things would have been done differently. I'm not as concerned, but I've heard the evidence that's been given to me, and frankly, has been given to me as well. I think in the R&D side, there is a separate sort of funding stream. So if you look at some, for instance, where the innovation fund monies that have been coming out, and it's quite extensive amounts of monies that have been coming out, and I encourage companies, providers to work with their local force or with their regional force in collaborative bids to do with that. On the on the area of contextual, I share a little bit of this concern with you, and one of the areas I have concerns with is where we use a private provider, and that private provider, say for instance, goes into administration. We don't at present time have the capability to require all of that conceptual research background information to be supplied back to us. That's something I'm looking at now, and in the legislation where we're probably looking at doing, we will probably have to put those powers in. Because if you've been doing X amount of work for 2 or 3 years in a particular area, and you obviously build up that knowledge base and that you can refer back each time. I'm not using scientific jargon, I'm sorry, I'm not a scientist nor a lawyer. But then, which is actually hugely useful to us. And then that company goes into a formal legal administration or receivership. For us not to be able to have that data and that information back, like we would do if it was in-house, I think is a dangerous situation to continue, and I fully intend to try and sort that out. I accept that there is still ongoing disagreement about what the government did at the time, but we are where we are. We need to make sure that we get the best possible outcomes and the best possible R&D and the best possible conceptual work as possible.
It's really about filling those gaps. So if I can move on to a sort of different area, which is that there are only a small proportion of cases involving forensic science evidence which reach the courtroom. Do you have a view on why that is? And do we need to understand more about why it is?
I think we do, and I'm looking now for some evidence being brought to me as to why that is. I must admit, when I first looked at my portfolio and I looked at this, considering I think the public's perception that forensic is, especially over all these strange programs on TV every night, showing you that every murder in the world gets resolved because of some tiny hair on something. I think the public's perception is that it will be much greater than mine was, and that it was much higher than that. So one, we have to find out, I think, why, and I'll commission that research to do so. But also, are we then saying, depending on what that research shows, is it because we think that forensics could do much better and it doesn't in court, or do we need to get better at it? And I think the analysis needs to be done not just here, but with our counterparts around the world. So in other words, we need to compare ourselves in the 7% you refer to, is that normal for America or the rest of Europe? No, we can't compare 100% because there's many of their legal systems are slightly different to ours, especially the American legal system. But I think that's an analysis that needs to be done.
Right, that's interesting. So there's a drop in demand, which makes it more difficult for the private sector providers to make a return on that. And they also concentrate on those areas of forensic science which they are repeat processes like fingerprinting and DNA analysis. Do you believe there's any way to, or do you have a strategy to incentivise the private sector to invest in in research in wider areas than those with big processes.
I think, as I alluded to earlier on, private companies will feel that they should invest if they feel that they can deliver a product which we are likely to buy, and very often, particularly with the nature of the way the homeworks works, we've had to incentivise that as well by giving them some confidence with the evidence base. In other words, we've been more prominently using the Innovation Fund monies. I think there will always be areas where the private sector may not be able to provide, because it's such a niche situation, which is why we continue, so forces will continue to do stuff probably at a national level. And that's exactly why the review that's going on at the moment should, and I stress should, address some of the concerns that you've got there. But at the end of the day, I think we need to understand why there has been a drop in demand in certain areas. We can't just say that and then address that situation.
Right, thank you.
Thank you. Tanya Mathias.
Okay, thanks. The forensic strategy says the government plans clear, simple, overarching governance structure. So, how is that going to be made possible?
I think at the moment it's quite opaque, and I think you've said the evidence that you've been given, and if we are believing in the devolution and the devolution powers, that governance structure has to come from the powers we give to the registrar, but at the end of the day, the police taking the control of where we are. Well, that's where this whole strategy is going. But we have to publish probably things that we wouldn't have published in before. Okay. I think the more we can do that, the more confidence there will be within the private sector, the more confidence there will be within the public. I've always had, I've been in 6 departments now, and I've always had an attitude that we should publish, and you have to tell me why we shouldn't publish. Now, that is quite difficult when I was in Northern Ireland doing terrorism. I mean, there are lots of things in the Home Office that would be difficult. But in this particular area, I can't see why we wouldn't be more open, rather so opaque as we are.
So for the Forensic Policy Group, are you going to publish minutes and the full membership?
I think wherever we can, that's what I would prefer to do, yes.
Will you be doing that? Because that, I believe, was highlighted by the previous Science and Tech Committee as being too opaque. So, again, I guess the question is, why can't those minutes and membership being published now?
I don't know the answer.
Okay.
And literally, I'm not as honest as that.
That's fine.
If we need to redact, we need to redact. But I don't like huge documents redacted. But we could write back. But my attitude is to keep the confidence of the market, the confidence of the public, which is probably the most important thing, and for the police to have confidence in the strategies we're going forward. Then let's be open.
Okay. So you can come back to us and tell us if there's any reason.
I tend to write back to a committee rather a lot after I've been there, because all the mistakes I make when I'm.
Absolutely appreciate, but you can come back to us and tell us if there's any problem about publishing that policy group now and the full membership. And just finally on that, what role do you envisage in the future for the Forensic Policy Group?
I think if it does what it says on the tin, it's probably one of the most important groups out there as to if we can get the right membership and the right people on that. Now, there may be some people on there that prefer not to be named, and we might have to respect that. I'll have to explain that. But I think it is if we are where we are, which we are, it's a vitally important group. Okay. It should do what it says on the tin.
Okay, it's great to hear you saying it should be, wherever possible, transparent and published. That's great. Thank you.
Minister, you've spoken quite a bit about your frustration with this police.
You can hear it in my tone, probably.
And the expression on your face.
Yes.
An open book. So could you just give us a bit of an indication of the timings which you're now expecting from this review, given the impact that it's having elsewhere? I'm thinking procurement and progress with the strategy now. And I suspect it'll affect the biometric strategy as well, or am I being too pessimistic?
Biometric strategy, well, on both, what I'd really like to do is to, frankly, go away and come back and give you a more definitive answer than just saying I'll do it as soon as possible.
Okay, so we don't have a date for the capability review.
I don't.
You don't have a date for biometrics.
I don't have a date that I can be confident to give to the committee on either.
Okay.
And on that basis, I'd rather commit myself in writing to the committee, and then perhaps that will commit my civil servants to pushing on as fast as I would like them to do.
That's terribly Jim Hacker. Okay.
Yes, that's interesting.
All right. I just want to go back finally to the national approach. I am concerned that if we have forensics providers or others who watch this back, they may feel that they're no more certain about what the national approach will look like. There's not going to be a national approach in procurement. There's not particularly going to be a national approach in research. So what is the national approach going to be?
I think perhaps I've misled the committee. That is not what I'm saying. Is we do need to have the reason we have the national approach is because if you go into one court with one group of people, you need to be confident that in the next court and then the next group of people. Okay. That's the national approach.
Right.
If people are providing a quality product which is accredited and we can, and that's exactly where we need to be. I want them accredited. I want the statutory powers in place, so that even if it's not just a private sector, it's when my police forces are not up to standard that we have that, and that the registrar has teeth. There's no point just having statutory powers that don't have teeth. We will consult on that and making sure that it's not kind of Big Brother, but on the other hand, there has to be a stick that comes with the carrot, and the carrot is that you are registered and accredited. The stick is if you need to make sure your quality is there, and then we have powers to do something about it.
Okay. So in essence, it's going to be statutory powers plus accreditation.
Yes.
Okay. All right.
Well, if you listen to what I said earlier on, I would expect everybody to be accredited if they're used. At the moment, that isn't necessarily the case. If that is the case, that they carry on using people that are not accredited, then I reserve the power to come back.
Intervention power. Okay, all right. And I just have a last question. The strategy, this is just to follow up on Graham Stringer's point, the strategy says that significant savings could be produced from this national approach, which could then be recycled into priority areas of research. And we've obviously heard concerns about that. Can you just give us an idea of what assessment you've made on this? How big would these savings be? Do you think they would genuinely provide extra money? Would we be able to increase research in this area?
I think, as I alluded to, there is money available within the innovation funds for research and work in this area. The saving area will be in duplication.
Yes.
And that's where. Extra money, I don't have extra money. Let's not be around.
No, but the implication here is that by changing the way in which forensics is delivered, it will produce extra money, which, and I'm quoting it, it says will be recycled into priority areas of research. And it says significant saving.
Yeah, I think there will be significant savings.
Okay.
But until we know exactly how that delivery points are going to be, whether it be a national, regional, or in clusters, or at force level,
right,
then we won't have a definitive. But there will be some modelling that I could share with the committee, which I'll come back to.
If you could share that modelling with us, we'd be very grateful. Can I thank you very much for coming in?
I find it fascinating. I find it fascinating trying to get my head around the briefing notes on it as well.
It's a very interesting topic, but it's also a very important one. It's the bedrock of our criminal
justice. Just on my last
system.
point, I think it is really very, very important. I'm not just saying that because the committee is doing an investigation of this, not least because we have to have the confidence that the court process, which we're using this forensics on, is actually the best in the world, and we can deal with that. Which is why I'm going back to Mr. Stringer's point, is why is that 7% right or wrong if in national comparisons? And the answer is that we don't know yet, but we will find out.
Okay, thank
and
you
I'll
very
share
much.
all of that.
Well, we are expecting a number of pieces of correspondence from you. We might write to you just to note down what we think we're getting, so we're all on the same page. But can I, in the meantime, thank you very much for coming in, Minister.